Henri Piffaut. Very warm welcome to Digital Markets Research Hub. I propose to structure our conversation with maybe asking you first to remind us the basic encyclopedic elements about the French Competition Authority, where it has been established, what's its mandate, what is its relationship with the government, and maybe some institutional setting, if possible, please.
I cannot be encyclopedic; it would take too long. But if I describe in a few words the Autorité de la concurrence, the Autorité was created by a law in 2008, and but actually it was a successor to the Conseil de la concurrence. And by the way it works is really that it has a number of objectives to implement competition law, be it to fight against anti-competitive conduct or to review measures that are notified to the French Competition Authority. That's one aspect. Another aspect is to advise the government on specific questions related to the competitive working on markets or on proposals to adopt laws or decrees which may have impact on some markets. And the last thing that we do is that we regulate professions like notaries or the I never know how you say greffier in English. I think it's bailiff or something like that. And a number of others. Now, how does it work? We are around 200 people, out of which there are 120 case handlers. The one specificity of the French system is that we have a separation between instruction and decision, a bit like in Belgium, for instance, where at the time of a statement of objections, the case file is transferred to the collège, to the board of the Autorité, who will then chair a hearing, a bit like judges would, and then ask questions, listen to both the parties and the services, and then would decide and draft the final decision. This is a system which is quite different to the one that you find in most administrative authorities in Europe, or even more so as regards the European Commission. This board is composed of, I think, 17 people to be checked, out of which there are 5 permanent members. I'm one of them. So 1 president and 4 vice presidents, and the rest are people who have another occupation, and they just sit with us and decide on these cases which are notified to us. They come from courts, they come from from companies, or they are also economists, university professors, and what else? No, I think I've given you a broad overview of it.
And obviously, you have very rich and fruitful experience of working in different institutions as well, and obviously also not necessarily working, but also engaging in continuous dialogue, multi-logue with your peers from other national competition authorities. In the European Union and beyond, how important the institutional structure is? Is it of purely technical nature, or you can see that it's really a decisive or important factor? What are your view on in this regard?
I think they are more than an initiative, because I used to work as a case handler at the European Commission, and I know what it is to build a case and then to have to defend it. At some point, it's not that you lose a position which would be neutral vis-a-vis the merits of the case, but still you have had to prove or disprove the case, so you're very much into the case. And it's very sound then to have somebody who was not involved into the investigation to decide on the merits of the case, and listen to what the case handlers, the conclusions that they have reached, and listen to to a opposite party, which may have a completely different opinion. So my experience is that we, at the board, we do not always follow what the services have proposed. I don't have any statistics in mind, but that happens very often, that we would say that this or that of the objections that have been raised are actually not they are not proven, or they do not amount to a violation of Article 101 or 102. So that happens often. If we were completely integrated, I think that would happen less often. So in a way, it creates the incentive to some extent for the services to take some risks as well in in the legal theories or in bringing new cases, and it enables us to take a position on these new cases or the more grain of the mill cases. So it's much more of an initiative, and it leads to actually a setting which produces, I would believe, higher quality decisions, but also a higher ability to take innovative steps when facing competitive issues.
And also, I wanted to ask you, 2024 is almost beginning, and we are now at the stage where the first act or in this long performance has been already trying to tame big tech or trying to protect/promote competition in digital markets has been already played in the phase of reports and first cases. We already are at a little bit more mature systemic stage in this journey. I wanted to ask your opinion. Do you think it obviously depends on different factors and different authorities, but as a common denominator, what do you are we on the right track? Are we still lagging behind? Is the gap between this asymmetry of knowledge is decreasing? Are we doing the right things, etc.?
We face a number of behemoths which enjoy immense market power, and markets which function in such ways that very often we have seen that competition authorities would intervene too late once market power has already been entrenched or expanded through abusive or anti-competitive behavior. And so competition authorities and the legislators have tried to address that. There have been the adoption of the DMA, which is starting to be implemented now. There have been in France a number of cases where we have treated very quickly complaints which had been brought to us. We have adopted interim measures in a matter of months, for instance, to correct distortions of competition in some markets and avoid that there would be a tipping point. So clearly, there are new instruments, and competition authorities have adapted to the new competitive environment. Now the question is whether in 2024 we will see the start of implementation of DMA and therefore a maybe more competitive or less anti-competitive functioning of digital markets. That's an open question. We needed something like the DMA. The DMA is probably not the perfect instrument, but you never have a perfect instrument. So we'll see via experience. One law is that of nature in a way is that rules are always a bit late compared to reality. That's the functioning of justice. So we shouldn't complain about the fact that we have behind the wheel, but we have to be careful not to be too far behind the wheel.
And let me ask you more specific question about the DMA. During the discussions, when different stakeholders were trying to calibrate the legal mechanism of the regulation, we hear the position of friends of the DMA stressing the need to use expertise, skills, resources of at least most mature, most advanced, most forward-looking agencies, or maybe the largest, let's say, national competition authorities, in more harmonious way within, while acknowledging the central mandate of the Commission and centralized enforcement, etc. What are your views about the final version? And what do you sense from your peers? Are national competition authorities more or less satisfied with the division of labor and competences between the Commission and member states more generally?
So I think initially the DMA did not involve at all the national competition authorities. I mean, there is probably a reason to that, because in a way it's legal basis, not competition law. But what France and others were saying is that it's really a pity not to use the ability to investigate and the technical knowledge that may exist at the level of national competition authorities, and we would be more effective collectively at implementing the DMA than just one body, one institution in Brussels. So I think the DMA as it stands is a nice it's a balancing act, and it's a nice balancing act because it makes complete sense that the Commission would be in charge of adopting the decisions, making the DMA work, but also it makes complete sense that the Commission could benefit from the investigative power of national competition authorities, which may have it leads to some kind of leveraging, multiplying effect. So at least at the French level, I cannot speak for other competition authorities, but at least at the French level, we think it's sound to work like that. Now obviously we will see how the whole machinery will work, because there might be cases which raise maybe DMA violation issues, but at the same time as competition law issues. And how do you deal with that? Is that and we will need to discuss a lot with the Commission and for when these cases will come up, but we don't know yet when and if they will come up.
You mentioned in one of your previous answers that the French Competition Authority has adopted recently quite speedy, quite quick decisions. And knowing this not controversy or delicacy of the situation with sharing competences in digital markets, which requires most agile and most proactive interference if we are serious about making some meaningful changes. We know some member states have adopted the rules which somehow try to complement DMA without encroaching into it in terms of competences. Does France have anything of this nature, or you are satisfied with the traditional ex post toolkit, or you had quite rich toolkit in the past?
So I cannot really speak on behalf of France. Let's be honest. But if I give you my personal view of that, I think the best answer to such issues are at European level. And my fear is that we would add noise if we would have a multiplication of national level complements to the DMA. I mean, after all, we should have one and only one internal market, and there is a risk of fragmentation of the internal market if we adopt, a multiplicity of regulations at national level, which would address, some kind of similar behavior or similar issues. That's one aspect. And the second aspect is that we have a much more convincing impact if we deal for the whole of Europe with these behemoths instead of dealing on behalf of France or on behalf of any other member state. So I think it's not necessarily the most efficient way to follow. Now, if there is a very clear gap and nobody is acting, it may make sense at some stage to adopt such national regulations, but I don't think that should be the first order solution.
But let me then ask you, Henri, how do you see this mission of the new proto competition rules for regulating digital markets? Where the priority should be? Should we be focused on fairness? I understand it's kind of 60-40 and it depends on the context, but in your view, is it more about fairness, about contestability? Is it more about vertical or horizontal? Is it about newcomers or inter-ecosystem, so to say, competition. Is there any kind of a broader long-term objective of these rules, or we are just doing trying to polish the markets where we can?
So, I mean, if you ask me for the objective of the rules, it's written into the DMA, and it's so there I would not add anything in just repeating what's in the DMA. Now, if you ask me about the what should be our priorities, which is another way to ask the question, how would you advise the DMA to be implemented, or how would you implement competition rules when dealing with the GAFAM, say, or any other digital platform? There we need to be careful. Sometimes there is a I mean, we have seen a number of Article 102 exploitation cases, and we have seen a number of 102 exclusionary cases. Traditionally, we would give priority to exclusionary cases because the main theory is to say you should make sure that there are not artificial barriers to entry and expansion, and make sure that markets are as contestable as possible. So therefore, focus on exclusionary. And when you have an exploitative case, it's a bit complicated to deal with it and to remedy it, because then you place yourself into the shoes of a regulator, and a competition authority should not be a regulator. But sometimes there is a regulatory gap, and there is an issue, and you cannot avoid it. And that's the reason why that you've seen a number of exploitation cases. We should not shy away, because the issues raised by digital platforms are most of the time, urgent to be dealt with. And so in terms of priorities, I would say you have to pay attention to all issues in terms of barriers to entry and expansion, so exclusionary cases, but you should not shy away from exploitation cases, because regulations do not address all the issues there.
You mentioned in one of your previous answers that you cannot speak on behalf of France, which leads me to kind of maybe my curious mind is overinterpreting this, but I wonder if is there any in the political establishment, are there different views on this kind of where the limits of such proactive I wouldn't say open-ended, but susceptible to being further specified toolkit is, and how it should be it used to deliver in broader societal or economic objective for the European Union as a polity, as an economic entity in the long-term perspective?
So are you asking me whether in the public debate in France, there are some people pushing for national regulations to deal with the digital platforms? Yes, there are, as in any other country. But and there's a debate over that, obviously. But the main answer for the moment is that Europe is the best answer.
And also, you mentioned that you provide the authority provides advice and recommendations to the government to promote a pro-competitive legislative environment. So I wonder what are your recommendations, and is it kind of the two-way street? Do you also hear the broader societal need as well, or is it something which you consider as a kind of as noise which pollutes the clarity of your more economics, neoclassical economics, price theory based analysis, which is robust and syllogistic?
So we are an independent agency by definition, and by European law as well. So we are not given any instruction in as to the priorities that we follow, and as to the cases that we decide. That's one thing. A second thing is also to be able to listen and to hear what consumers expect, and to understand what they, sometimes when you're dealing with non-price factors in terms of competition, you have to understand how consumers behave. So if consumers, for instance, pay more attention to the fact that their privacy should be better respected, then it may be that privacy becomes an important parameter of competition, and then you have to pay attention to that when you are making cases, examining measures or examining behaviors. Now, if people were claiming for government intervention on digital markets, that's not something that belongs to consumer welfare. So that's part of a background, but that would not influence at all the way we decide cases.
Let me ask you then another kind of delicate question, maybe. The new Commission reading of merger Article 22 of merger regulation, and you have experience in the past, technical, nuanced experience in dealing with mergers. What is your view on this trend?
So I think it's not a new reading. It's a reading that has always been there, but it's more a matter of priority. So and my take on that is that there was a gap in the implementation of merger control. It was clear that some dominant companies were buying out smaller competitors, but that was not dealt with by any of the merger control rules in European countries. Why? Because we are in markets which are growing very very quickly. So the value of a small company in terms of competition is not at all represented by its turnover. So here there was an issue, and France had advocated for dealing with that issue for quite a while. And we thought that Article 22 was the best route, because that's a rule that existed before already. That was there, and you didn't need to change the thresholds as was done in other countries, and include value-based thresholds, for instance. And which you would just need to say, well, as from now on, we will apply Article 22 to such transactions. So I think it's a rule that existed already in the first merger regulation of. Was it adopted in 89? I think it was adopted in 89, implemented in 91 or at the end of 90. But and we just used it. It was there because there was a gap, because in some countries there was no merger control rule, but the gap existed in some way still today, and so it's there. Use it.
Another issue which generates a lot of publicity is until recently not known for the broader public phenomenon of programmatic advertising. And French Competition Authority not only was mindful of its paramount significance for the functioning of digital markets, and maybe for converting the digital muscles into monetary pecuniary muscles for the largest companies who control and basically channel the entire machinery of programmatic advertising. And you knew it, but you also were very quick and proactive in enforcing traditional exposed instruments against the largest player in programmatic advertising, against Google. May I ask you, and also imposing global commitments, if I understand correctly, remind us about the case, and how do you monitor how commitments are being complied with, and are you satisfied with performance?
So I'm not going to tell you whether we're satisfied or not, because that would be a board decision. And that would need I mean, we closely monitor what Google is doing. But to tell you the whole story, early in the 2010s, the Autorité did some kind of sector inquiry as to the digital advertisement market, of the online advertising market. And there was a second one at the end of the 2010s, and that was very helpful in two ways. first, it helped us to build the knowledge, the technical knowledge of these markets. These markets, I mean, digital markets in general, they are very technical. And the online advertising one is in a way, very, very technical, even more than very technical. And so we built knowledge, human knowledge. And the second thing is that we could identify a number of possible issues, as well as position ourselves as an agency who could deal with the issues because we had built knowledge. And so naturally, some people came to us and said during that sector inquiry or afterwards and said, well, you know, we believe that there's an issue there, there's an issue there. And so we have adapted a number of decisions in relation to online advertising markets, not just the display advertising market, but also the advertising based on search. Now, the one to which you make reference was eventually a commitment decision, where Google said that from now on they would not do any self-referencing, and they would consider the various customers of its advertising platform on a equivalent basis, a non-discriminatory basis compared to its own services. I'm not going to get into the technical description of the functioning because I think it's really outside of the scope of that, and I would need to draw something to make it clear. But the basics of the case was really that, and the way it has been solved was to accept this undertaking by Google. Now it's a rather technical one. There is a trustee which is in charge of making sure that Google complies with it, and then there's an interaction with the authority from time to time on these aspects. It's mostly with the services because the college, the board is not involved into making sure that the commitments are complied with. Why so? Because if we were to take a decision that would sanction a given company, but because it's not complying with its undertakings vis-à-vis the authority, there would be an infringement of a separation rule that I was describing earlier on, if we were involved into the monitoring of the compliance.
This somehow links to my question, which I wanted to ask you. Again, in the context of the DMA, we also refer to commitments, but because this modality is a little bit more, or envisages more proactive approach, more to tailoring competition, do you think, what are your view about the very mechanism of commitment? Is it sufficient to give the first move for the companies? I understand that it is for export, or maybe not, and maybe there could be also an opportunity to expand it, given somehow to the enforcer the room to say, okay, that's what we want you to do, or you still have the opportunity to do it in the course of this dialogue.
So, when we adopt a decision, an infringement decision, leaving aside commitments, we can impose a fine. What I think is a lesson to be drawn from the experience during the past 10 or 15 years is that fines have not provided an incentive to comply with competition rules for digital platforms. So what we have seen more and more is that competition authorities, and that's the case of the French Competition Authority, have not only adopted fines, but have adopted injunctions into their infringement decisions, saying to Google or others, you should do this and should do that, and we ask you to report to us on the way you're going to do it, and we will have an interaction on how you do it. So the basic conclusion is that you need not only to find infringement and impose fines, but you need to be involved into how the company is going to behave in the future, is going to change its behavior for the future. A commitment decision is a bit different in that there is a constructive discussion dialogue between the company and the competition authority, but it's only a commitment decision, so it does not create law, and it does not provide, in a way, legal clarity for the future. And so its impact on the market not only that platform, but other platforms, it does not provide a stronger incentive to comply with competition rules in the future as a infringement decision would. But you have to accept that at the same time we have limited resources. So at some point you may have to make, as a competition authority, choices. So in this case, I'm going to go to an infringement decision. In that case, I'm going to go to a concurrent decision, and try to make a mix of decisions so that it provides legal clarity and the incentives for competition for companies to comply with competition rules.
I get it, absolutely. So just to be clear for myself, there is no shortage of opportunities to communicate what the authority wants in case you really in the course of commitment procedure, in this or any other case, if the authority really does know what it wants, it still has sufficient room to convey the message to the supposedly wrongdoing company. Even within the DMA, there is no need to grant the opportunity to play with white chess, so to say.
Within the DMA, we will see what happens. One of the issues of the DMA is that it has a set list of do's and don'ts. So it creates some kind of per se rules that companies have to follow, but these do's and don'ts are limited, and they probably do not encompass the likely behavior in the future, because they provide incentive for companies to behave in another way to achieve the same objectives. So perhaps there will be new rules that will be needed in the future. And so one of the challenges for the implementation of the DMA will be to how do you create these new rules? Do you create them by using the provisions that enable to identify new rules, or do you create them by negotiating with the companies on their behavior? I mean, on the first, it's a general one, so it should apply to any company which is caught by the DMA. On the second, it's more tailor-made, and my guess is that at some point you will have some tailor-made ones, because each of these platforms has a distinct business model and has a distinct ecosystem. And you may have also some new general rules, because new issues which belong to all of them will emerge. Let's say let's suppose that all of them use AI. Sorry. Then there might be a need for a new rule dealing with AI, which would apply to all of them. But perhaps this one is going to have a kind of behavior which is not used by others. So why have a general rule for this one?
Very interesting. I think it resonates very well with what UK plans to adopt, with granting to the enforcers so much discretion is to do it bespoke. Final question on this case: do you, while investigating it and obviously looking at it into nitty-gritty, do you see it? Would it be correct to say that it's kind of new trend of using privacy as a shield, justifying somehow otherwise anti-competitive, or justifying anti-competitive conduct, saying, look, don't ask me how I earned my first billion. Now I learned I'm happy to be mindful of privacy of our users, etc. And it is, yes, it is anti-competitive, but look how many benefits we deliver in terms of privacy. I refer to Privacy Sandbox, ATT, and Private Relay, and cascade of other similar initiatives, let's say, mainly in the inter-ecosystem competition, but also vertically.
Yeah, no, it's a fair point. It's funny because this morning there was the official signing of a cooperation agreement, or cooperation declaration rather, between the French privacy regulator, the CNIL, and the French Competition Authority. So that's really on the headlines for today, this question. So yeah, that's a theory of harm which has been brought, that with the Privacy Sandbox or with the ATT window, there would be a kind of use of the privacy obligations or privacy justifications in order to raise barriers to entry or barriers to expansion for competitors. And that's something which is being investigated by the French Competition Authority as regards ATT, and by others as regards the privacy sandbox. So I cannot, comment whether it's fair or it's not fair as a theory of harm. But more generally speaking, you have to make a distinction between the respect of privacy obligations, which is, into the RGPD, where it's an obligation. There might be different ways to comply with the obligation, but it's an obligation. So in a way, these companies, they don't have that much leeway to implement that. And then there is there would be a behavior by companies saying, I want to do more than what is required. And there, the respect of privacy becomes a parameter of competition. Before it was a fundamental right, and here we get into a space where it's just a factor of competition, and there the competition authorities have or may intervene in the way that this factor of competition is being used, either to adopt pro-competitive behavior or more anti-competitive behavior, and to try to balance this objective, which may benefit consumers, with the impact on prices or impact on barriers to entry and expansion. And there the set of analysis is really already does really exist. It's is it a section of competition under Article 101? If yes, should we is it something which might be exempted on the basis of Article 101(3)? And that's a very classical kind of analysis.
Another attractive phrase or word, actually, or term, which it's hard to open a competition law, any competition law journal without identifying it in manner, is ecosystem. So and many people refer to it as a kind of new attractive term, which helps us to understand better the complexity of digital markets and the dynamics of competition within it. Others, more cynical maybe, or more skeptical, say that, look, we just got rid from the dictatorship of market definition, and now we try to impose upon ourselves even more complex, even more context dependent phenomenon with so many possible. So my question is, as competition agency, do you think you need it as a helpful, do you consider it as a helpful epistemic tool to understand better some theories, the nature of markets? And do you see some potential pitfalls with it as well?
So, I mean, I'm always very skeptical as when a buzzword becomes adopted by many people at the same time. So, but when you would, my way to look at cases is to forget about the market definition, to forget about, say, ecosystems or whatever, and to try to understand what's the root of market power, where does it come from, and how is it expressed. And in these markets, what you find is that the source of market power is, say, a data set, or computational ability or whatever, which does not belong to a given market or to a given activity, but which is used and leveraged in a number of connected markets. And so if you start to look at a given behavior on a given market, you may lose actually the way market power is sourced, is caused, and is used. And so you very often in these markets, you have to take into account competition, or either the working of competition or the impact on other markets to the one on which the initial move was noted. And so whether you call it conglomerate effects or ecosystem, because it's a bit more different than just conglomerate effects, it does not in a way matter. What matters is that your theory of harm reflects reality. And I think that's really what competition lawyers, competition economists, agencies should look at foremost, is really understand the theory of harm and make sure that it sticks to reality. And then you may set it up against the classical kind of reasoning that we find into decisions, definition of relevant markets, and whether it's a horizontal effect, a vertical effect, or a mix of both. This language is there to reflect realities, but reality should not be adapted to the language.
And obviously, we know my last question is that the competition becomes very popular career choice now. It was always, but now it's getting even more so with all this attention generated by over the last years. What would be your recommendation to maybe students, but also those who will want to join in the following years your authority? Do maybe you I imagine you take decision, or you are mindful of the decisions. What are the selection criteria, formal, maybe less formal, those skills which are you feel the shortage maybe, and maybe some elements which are less clearly, which are impossible to list on in the essential criteria, so to say?
Yeah. So my advice would really be, you need to understand businesses. All of you probably know by heart the law, and it's important, obviously. But foremost, what is important is to understand businesses. And if you don't understand businesses, you're going to apply, in a way, blindly the law, and that may have unintended effects on consumer welfare, the working of the economy. If you understand businesses, then you would end up making cases that make more sense.
Henri Piffaut, thank you very much for sharing your excellent ideas with all of us.
You're welcome.